Welcome to another intense courtroom breakdown where real lives, real choices, and real consequences collide. Today, we're diving into a wild docket featuring high-speed chases, blood alcohol levels off the charts, and even a murder extradition case. From reckless drivers tearing through Texas freeways to jaw-dropping statements that leave judges visibly stunned, this is one episode you won't want to miss. Keep your eyes on the screen and ears peeled, because the truth behind these charges is about to unfold in ways no one expected. Buckle up, this courtroom's on fire.
Good morning, sir. You speak English? Yes. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
Thank you, Your Honor. On April 10, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling at a high rate of speed, failed to signal a lane change, weaving in between cars, and following too closely behind other vehicles. The law enforcement officer matched the defendant's vehicle at approximately 100 miles per hour. A traffic stop was conducted, and the law enforcement officer made contact with the defendant, who stated he did not know he was going that fast.
Okay.
And if I could, Your Honor, just real quick, basically we had the opportunity to look at the videos. My client has a radar chip in his car. We've shown that in the state. His car wasn't going over 90 miles an hour, and he clearly using his indicators. And on the video, the officer says that he doesn't know how fast he was going.
Pause right there. The defense is already trying to poke holes in the officer's claim, noting the car didn't exceed 90 miles per hour and pointing out the lack of official pacing or radar confirmation. But here's the thing, speed isn't the only issue. Weaving, tailgating, and aggressive driving patterns can all still establish reckless behavior. Let us know in the comments. Does the officer's vague estimate weaken the case, or is the erratic driving alone enough to justify the charge?
Car has no radar, but he thinks it's 90 to 100 miles an hour.
I mean, you're going through video. This is just probable cause hearing. We could set it for something, but
There is no actual speed that he paced my client. So there is, just to let you know,
speeding in and out of traffic, falling too closely.
according to the officer, right?
So I'm going to find probable cause for
That's
now.
fine.
We can always set it for, because I have to give them the
No,
opportunity.
absolutely, Your Honor,
No.
absolutely. I
So
think the chief, once he's, done with this trial, he's already told me it's going to be either a class dismissal or straight up dismissal.
Sir Albazen, I'm going to find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in this manner again. If I find that you drive at speeds of 90 to 100 miles an hour, doing reckless driving, weaving, speeding, I'm going to revoke your bond and put you in jail. Just, we have enough crashes on the road. Don't add.
This is where the judge lays down the law, literally. Notice the tone shift? She's not just warning the defendant, she's sending a message to the public. No more street takeovers, racing, or stunt driving. It's crystal clear, one more slip-up, and it's straight to jail, no questions asked. And get this, she even acknowledges he has a good lawyer, but reminds him that won't help if he gets caught again. Classic tough love, courtroom style.
You know what I mean? No reckless driving, racing, street takeovers, donuts, nothing of this matter. Got a great lawyer. He's going to help you out. Stay in touch with him. We'll give you guys time to work on the case. I'm going to have bond conditions created so you promise us that you're not going to drive like this. If I find that you do, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay, so we'll have you sign a reset. Just have him take a seat. We'll get bond condition created, and then once you sign it, at that point, you can leave. Leave. Hey, Cole, can I borrow you real quick so we can do PC real quick?
Yes, Your Honor, of course. My apologies.
This is Mr. Bias. B-A.
Mr.
All right, Mr. Bias, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Can you get the name one more time, please?
Let me give you a cause number.
Yes, sir.
Tell me when you're ready. 256
256
0257.
2257. All right, thank you, Your Honor. On April 15, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling on the Gulf Freeway. The officer visually estimated the motor vehicle speed to be between 115 and 120 miles per hour in a 60-mile-per-hour zone. The officer attempted to catch up to the vehicle and observed approximately 15 to 20 lane changes from across all 4 lanes of traffic around other cars that were obeying traffic laws. The officer had to travel at speeds in excess of 120 miles per hour to catch up to the defendant's motor vehicle. Officer caught up to the motor vehicle and paced it at 115 miles per hour for approximately 1/4 mile. A traffic stop was conducted and the defendant stated, "I effed up."
Hold up. Did you catch that? The second driver was clocked at 115 miles per hour, weaving across all 4 lanes 15 to 20 times. That's not just reckless. That's a full-blown danger to public safety. The officer had to chase him going 120 miles per hour just to catch up. Imagine being on that freeway. Question for you, should extreme speeding like this carry harsher penalties, or is a stern warning and bond condition enough?
Run his license, please. Mr. Bias, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive in this manner anymore. If I find that you're a danger to my public, it's not going to go well for you. Do you understand?
Yes,
I will revoke your bond, put you in jail, no more PR bonds.
Yes, sir. The license is open.
You are not allowed to drive unless you have valid Texas driver license and liability insurance in your name, and that is a condition of your bond. If I find that you do, or you drive without, likewise, you will go to jail, no more PR bonds.
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. I'm going to have the state create bond conditions that you're not to drive in a reckless manner. You're not to participate in a racing street takeovers, donuts, anything of this nature. I will do everything in my power to protect my city at all costs, Mr. Vice, and I want you to understand that. And if I find any more of this, it's not going to go well for you. Do you understand?
Yes, sir.
Do you mind filing those conditions, Cole?
Yes, sir.
For now, I'm going to have you sign a reset with Victoria. We will have you take a seat while we get your bond conditions. Once you have signed them, then you'll be free to go. Please. You are Mr. Billings?
Yes, Your Honor.
Mr. Billings, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high level of alcohol. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 7th, 2024, in Harris County, Texas, officers responded to a motor vehicle accident. The officer arrived and observed 2 vehicles that had been damaged and rendered inoperable. The defendant was ID'd by his Texas driver's license and ID'd to be the sole occupant and driver of the motor vehicle. The officer relocated the scene to a nearby parking lot to safely conduct the investigation. The officer determined the defendant was at fault for the accident after speaking with all the parties involved and reviewing information collected at the scene. The defendant stated he had left a bar called Sugar Room. The defendant stated he drank 2 beers at the bar. The officer noted that initially the defendant was not even aware that he had been in an accident. The officer observed the defendant to be lethargic and confused. The officer observed the defendant to have slurred speech, glossy eyes, and trouble maintaining their balance. The officer had to ask questions multiple times to obtain simple information from the defendant. The officer did not notice alcohol emitting from the defendant despite defendant's admission to drinking and defendant's apparent physical and mental impairment. The officer suspected the apparent impairment of the defendant could have been caused by some kind of narcotic. The defendant refused to perform standard field sobriety tests. The DIC was read. The defendant agreed to provide a blood specimen, and the lab results came.
That 0.17 blood alcohol content? That's more than double the legal limit, and it's not just the number. The defendant was confused, lethargic, unaware he was even in an accident. No odor of alcohol? That's why the officer suspects narcotics too. But here's where it gets even more serious. The judge tells him not to drive even if a building's on fire. That level of accountability is what separates a slap on the wrist from real consequences.
Back to a 0.17.
Okay. Any prior DWIs? And does he have
This is the first.
and valid license?
Judge's license was recently suspended ALR. He will not be driving. He has a 90-day suspension.
I want you to understand something, Mr. Billing. I take this extremely serious. I don't care what you have to do in your life. If you do not have a valid license and liability insurance, you are not allowed to drive, and that is a condition of your bond. You will be signing an affidavit with me today promising me you're not going to drive. I don't care if there's a burning building and you have to say 50 kids. Do not drive. Do you understand?
Yes, Your Honor.
Nothing you can say justifies getting into a car and driving. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. If you get called upon to go take a test and you fail to go, a warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Okay. But now I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you'll sign a reset. After that, you'll get to Roxanne where you will get your bond conditions and then you're free to go.
Thank you, Judge.
Yes, Your Honor.
Yes. Oh, I don't know. Wait a second. Bond? Is he on bond? Did he make a bond?
No, Judge, we're asking for a PR bond. I thought you said you granted him a PR bond.
No, we haven't. I assumed that, no, I haven't given PR bond.
Yes, we're asking for a PR bond. He was not arrested.
Okay, come up, Mr. Billing. I didn't realize that. Thank you for saying something. All right, Mr. Billings, I'm going to give you a PR bond today. There's a warrant for your arrest, so I'll give you a PR bond today, but I want you to understand, I don't continue to give PR bonds after PR bonds, especially if you're a danger to my city. I'm going to give you one now, but there won't be multiple ones. You understand? Okay, all right.
Thank you, Judge.
Done. Thanks. Hi, good morning.
Justin Harris on the fugitive docket.
Justin Harris?
I know. I kind of laughed at that,
I'm just kidding. I'm just kidding.
It's funny, because I just seen him yesterday. Justin Harris is on the fugitive docket. He waived at magistrate court and has vehemently changed his mind.
Should we? You're laughing. Do you want me to bring him out?
So Judge, if you want to bring him out and admonish him, Philadelphia, from what I hear, does want him. Is that right, Amy?
Yes, we're on their way here to get him today, but if he's withdrawing his waiver, of course they can. If he intends to withdraw his waiver today, they obviously can't pick him up today, so.
If they're gonna get him, they're gonna, hey, Deputy, you mind bringing out Justin Harris, please?
And then while he's coming out, do you want me to reset the Dustin Eli hearing?
Have they done anything upstairs? It's on docket today?
No, they haven't. So I was going to talk to you about that. If he takes TDC up there, would you consider?
If he takes TDC, there's nothing I can do.
I agree. And that's, I mean, and I hate to say that because I don't know what they're doing, but if we could
Obviously, if he
reset it, I
takes-
think it's an option.
No. If
Okay.
it takes TDC time, I'm putting
Okay.
things back.
And I hate to say that because I don't know what'll happen in May,
no-
but I think it could be worked out. Yes, Judge. Your other option was to put him into SATA.
No. My feeling is that he's probably gonna end probation, right?
No.
Really? Have they not offered probation upstairs?
They might, but considering the nature of it, if they do, they're going to require SATA, right?
I mean,
Right. And that's the end goal is I don't think he wants that.
he's willing to go to TDC instead of going to treatment for real?
Yes, I know.
Well, I mean,
I've talked to him. I know, and I'm going to set up another meeting with him to go over things, but
be the horse to water.
you know, there's only so much I can
I know.
admonish.
Yeah, so
They just.
that case is set for May 12th,
So
I guess.
if I can just get like a day or two after that.
Absolutely. Good morning, Mr. Harris. Good morning. So you're wanted out of another state. You already waived, and your lawyers tell me now that you would like me to set you a bond so that you can go out and go turn yourself in.
Oh, no bond. I just wanted him admonished on the extradition timeline.
Okay, so you've waived. What happens is we give the demanding jurisdiction, which is who?
Philadelphia County, Pennsylvania.
Okay, what's he wanted for?
Murder, endangering welfare, and.
Okay, yeah. So you're wanted for murder,
This one just took a dramatic turn. Justin Harris isn't just another defendant. He's wanted for murder in Philadelphia. And check this out. He originally waived extradition but now wants to take it back. Sorry, too late. The judge explains the process clearly. If you refuse extradition, a governor's warrant gets triggered, which can take up to 90 days. This isn't traffic court anymore. We're dealing with life sentences and interstate justice.
And what else?
Endangering welfare, another third charge that's REAP.
Well, they,
Rape?
It's they spelled it REAP.
ain't no damn rape. I ain't raped nobody.
I don't know exactly what that one is, but for sure.
So understand that we just get the teletype that tells us what it is. I have no idea. Here, we don't fight the case. We only try to establish identity. If you are if you are the person that is wanted from the other jurisdiction, I don't know. The good news is, though, is that you've waived and they're coming to get you today. So we could really get you on the way back to Philadelphia
No,
today.
I said I'd rather put the 30 days in. Didn't I tell you that?
You did, but I'm just admonishing you. It's not just 30 days. It's
So
30
what
days.
happens now is,
Yeah, 30
I just want to make
days.
sure you understand that.
so what happens now is if you refuse, which is your right, they'll get a governor's warrant, but that'll take up to 90 days to get,
I'm
you
fine with
know?
that.
And then the pickup is 30 days after that, just to make
Okay,
sure we're good
I'm
with
fine with
timelines.
that. I'm fine with that. Cause I'm
Right,
trying
so-
to get everything in order back to there. I'm not about to broad rush, be blind, go back to Philadelphia. And then I don't know what's going on inside my county, like, as far as being held inside, like, it just.
You want it from other counties as well?
I have no knowledge of that at this time, Your Honor. I would have to run a criminal history check if I could get one of the prosecutors.
So I guess you just want them to get a governor's warrant, then I'm assuming
Yeah.
then. Okay, so if you just want to go ahead and, you know.
I've got to find them.
And then Judge, the waiver withdrawal should be in your queue.
Okay, I'll sign it and then, all right. So I guess let's set it for 45 days. What do you think?
I had him set out for 30 days.
Okay, not a problem.
So it's gonna be May 23rd.
Okay, so the problem is you have to understand also is that when someone is charged with a crime that has a potential life sentence, I can't give you a bond even if I wanted to. Just that's the way the statute reads. So, okay. All right. Good luck to you, Mr. Harris.
Thank you.
Thanks, Judge.
Good job.
Don't know what to do about Mr. Burnett, or Mr. Bennett. I know that you said he had a prescription,
He does.
right? But that prescription was from what, 6 months ago or something?
I think he has he has numerous valid prescriptions. Do you not? Can I bring him up here and talk to him?
Yeah, but
He does.
otherwise I don't want him to use, you know? I mean,
I get that. That's where, and as a lawyer, it's hard for me to sit here and tell him like, hey, don't listen to, if the doctor's, again, I get the look and feel for these types of prescription, just give them, there's tons of pill mills in the city. I get that stance, but then it's also hard for me to say as a lawyer, well, how do I say that this guy needs it and this guy doesn't when I'm not a doctor? And so it's hard for me to tell him, hey, don't do what the doctor says when
when did we do our first?
I feel like I've been here once a week, every week for the last 3 weeks on him. But
That's what
I mean, it's fine. Yeah, I get it.
No, I
I
mean, that's
get
why
it.
they're so
And
difficult.
it's not,
I want to,
I'm not upset by that or anything, but
Here's what I want to know. I want to know when it's going to stop. He's got a prescription. If I remember, it was for 90, right?
this probably sounds right. Yes, Your Honor.
So I want to know when it's going to stop because I'm not going to let it continue for the next 6 months. You've got 90. You're not going to sit here and tell me that 90 is going to last you for the next 6 months and that you're going to continue to use. It's not going to happen. Come up, Mr. Bennett. And what's the purpose for? Is it for an injury? Is it for?
I think it's I could have sworn he was in a motor vehicle accident, but yeah. What, are you on pain medicine for injury or what?
I was in a wreck, but I haven't been using.
You're still testing positive for it?
When the last time I tested positive?
Last week.
I wasn't positive for it.
No.
Or
Tested positive?
we were here on, was it Thursday or Wednesday of last week?
Last week, I did not test positive.
This is Mr. Bennett. When was his last UA? Please. If you're clean, I'm jumping up and down, really.
Of the 17th, you told me the same thing, and I went and did my drug test, and I ain't have it in my system.
Let's see, I don't know. The last one I
I got
showed.
an email that he did, so that's why I assumed that he did. But I don't
That's
know.
and that's what I got too.
Last time I did a drug test, it wasn't in my system. Where they shake the bottle and show you right in your face.
His last drug test was on the 22nd, so it was yesterday.
And
No.
I didn't.
results,
They were presumptive positive for THC.
that's it.
That's it.
Okay.
Wonderful. That's great. I'm proud of you. Great job. Great. I'm gonna test you like crazy still. Don't use, please. I'm gonna let you go for the time being for the weed. But, you know, after about 50 days, if you're still testing positive, that means you're continuing to use. Just don't. All right?
So
Okay, we're good. I'll
Okay.
continue supervision.
Thank you,
Okay,
Judge.
great.
So let's recap. From reckless racers clocked at 115 miles per hour to DUI suspects claiming confusion over crashes and even a murder extradition hearing, this courtroom session had it all. But beyond the drama, we saw the law in motion, a judge enforcing accountability, attorneys pushing back, and defendants facing the real-world impact of their actions. What would you have done in these situations? Drop your thoughts below. And if you found this breakdown as jaw-dropping as we did, don't forget to like this video, share it with your courtroom crew, and hit that subscribe button so you never miss another Real Case reaction. Until next time, stay smart, stay safe, and stay out of trouble.